Alpha Security. Ms. Kelly.
Good morning, Your Honors. Mary Ann Kelly, and together with Dennis Chung, we represent the plaintiff below in this Title VII action, Jacqueline Rice. In a nutshell, the issue before the court this morning is, did the state court lose jurisdiction over Ms. Rice's Title VII action before the defendants removed it to federal court, such that it arrived, that it was dead on arrival in the district court? We submit that the answer to that question is a resounding no. The state court did not lose jurisdiction. And indeed, there is nothing in the state court record, no order, no notation, not even a motion from the defense, suggesting that the state court had lost jurisdiction. Defendant's challenge to Ms. Rice's case, filed in the federal district court, relies on Virginia's Rule of Procedure 3:5E, which rule of procedure was codified at 8.01-275-1. But in the federal district court, the federal rules of civil procedure apply and federal law applies, as the United States Supreme Court explained in the case of Granny Goose, which we cited in our reply brief. Federal Rule of Civil Procedure 81C makes it very clear.
Could you speak up just a little? I just want to make sure I hear you.
Okay. Sorry, Your Honor.
Thank you so much.
Thank you. Federal Rule of Civil Procedure 81C also, by its plain language, makes it clear that in the federal district court, the federal rules of civil procedure apply, and the Granny Goose case cites that and says that federal law and federal civil procedure apply after removal. Accordingly, for defendants to move based on state procedure is inappropriate. They really have waived their opportunity to seek dismissal in the federal court based on a state rule of procedure.
Well, except you don't mean to suggest, do you, that post-removal a defendant couldn't move for insufficient process or insufficiency of service of process, do you?
They can move for that, but then in that instance, if the district court finds that there was deficient service, the plaintiff would have a right under 28 U.S.C. 1448 to reserve and Federal Rule 4M.
Of course.
Yes.
So my point is simply that I guess I'm focused on what I regard as something of an overbroad statement by you just now, to the effect, as I understand it, that once removal occurs, state rules of procedure are irrelevant. Because in the case that I put to you, whether there was effective service would be determined under state rules for service of process, right?
That's true, Your Honor, but to apply the federal, for the federal court to apply the Virginia rules of procedure as was done in this case, I think is what I'm taking issue with.
Okay, and so I'm trying to understand the difference between what you agree to, namely that a challenge to sufficiency of service post-removal would lie for a defendant relying on state law, as opposed to what you contend here, if I understand it, is that once the case was removed, again, this is not, I don't mean to suggest you absolutely mean this, but it's almost like you're saying rules under the Virginia practice are irrelevant. I don't think they're irrelevant.
They're not.
I don't think you're really saying that.
They're not entirely irrelevant, Your Honor, but I think the important issue here is that Judge Lee erroneously found that based on a Virginia rule of procedure, the court lacked jurisdiction.
Now, can I explore that with you for a second? When you say lacked jurisdiction, I take it you're using that term as a shorthand for this rather curious term of jurisprudential death?
Judge Lee, Judge Lee used the term, found that he had no jurisdiction because the case he found was jurisprudentially dead on arrival.
So, which means it was jurisprudentially dead before it left Virginia,
Well,
right? It didn't die on the way.
but it wasn't
If
dead.
it's dead, it didn't die on the way. It died while it was still in Virginia. And that's what you mean by Virginia lost jurisdiction. In other words, there was nothing there to remove, in effect. Is that
That's what the defense is arguing, that the Virginia court lost jurisdiction.
okay? Right.
And that could only be,
Well, lost jurisdiction. Again, I'm sorry, but Virginia didn't lose jurisdiction.
no, sir, they did
Virginia's
not.
always had jurisdiction over this kind of action. Question is whether the case came to an end. Isn't that really the question? Not whether the Commonwealth lost jurisdiction, whether the case ended.
Well, there's no question the case didn't end. The state court speaks for itself at the joint appendix on page 8 in its final order when it says that this case is, quote, removed and stricken from the active docket of this
that
court.
was sometime before you effected service.
No, sir, that's after. That's
There
after
is no
service.
final order of the Virginia court because of the removal. Judge Lee, in effect, was sitting as a judge of a state court, wasn't he?
He was, in effect. But just to correct the record, Judge Davis, this final order is dated September 19th, and it is the final order noticing that the notice of removal had been filed. So it is the final word of the state court that because of the removal, and only because of the
What was
removal,
the actual date of removal again? Just the exact day?
the date of removal was September 13th. It arrived in the
year?
2012. And I think, Judge Davis, you're really hitting on this, that there's nothing in the record to suggest that the Virginia State Court lost jurisdiction. The court never even squeaked a possibility of that. The defense, we submit to deprive us from, among other things, the opportunity to file a non-suit and the opportunity to have a hearing had we so chosen, in which the state court would have exercised discretion. The worst possible situation for the plaintiff in the state court is the defense would make a motion to dismiss based on a failure to serve within 1 year.
But the discretion is based upon a due diligence on your part. And I don't understand there to be any kind of claim that due diligence was exercised.
It is not based just on due diligence, and the Fry case, Your Honor, squarely addresses that. In that case, the plaintiff waited until the 365th day to appear at the courthouse and request a summons, finding the courthouse closed. And even though there was no showing at all from that plaintiff that there was a single attempt before the 365th day, the Virginia Supreme Court read the 1-year service rule in conjunction with the computation of time and said the plaintiff should have the 365 days, no showing of due diligence.
It seems rather dramatically to distinguish that case from this one. It seems. If the courthouse is closed on the last day and the plaintiff can't get the summons, obviously the plaintiff can't serve the summons on the last day.
Exactly so, Judge. And
that's not this case.
Well, it is this case to the extent that the plaintiff had non-suited her case for 17 days. And the defense concedes, as it must, that the plaintiff could not have obtained a summons during those 17 days. So that...
Why did you move to vacate the non-suit? I mean, why not just recommence the action within, 6 months of the non-suit order? I mean, it seems to me you've created problems for yourself that you didn't need. You by moving to vacate the non-suit, you ran into this service of process problem, and that might have been avoided altogether had you simply sort of taken them, simply recommenced the action within the 6 months of the non-suit order rather than seeking to vacate the non-suit.
We did that, Your Honor, because defense counsel called me.
You moved to vacate the non-suit.
This is the reason we moved to vacate, which I believe was your question. We did that because after the court entered the non-suit, but before 21 days had expired, defense counsel called and made an argument to me that were we to refile, our statute of limitations would be blown.
And you were persuaded by that argument?
Defense counsel made it, and out of
You were persuaded.
Well, I'll tell you that this is exactly what happened. In abundance of caution, we did some research, and it's very short. We had only a few days left. So we vacated, and upon consideration standing here today, that was probably unnecessary.
Why do you
It was unnecessary because we could non-suit, but in the heat of...
Who did the defense counsel represent? The defendant?
I'm sorry?
The defendant, right?
Yes, sir.
So was it in his interest of his client to help you keep a suit alive against his client?
Probably not, but that's in fact what happened.
Why would you take their advice to do that?
Well, I can't say why he did it, Your Honor, but...
It would be inappropriate for him to give you something that will help keep his client in court. My goodness, if you're running into a cliff and my client benefits from your falling over it, as long as it's legal, I'm not supposed to stop and say, look out, one more step, you're on the cliff, you're supposed to go on over there. So why would you do that? I don't understand that. You know
to give us a little bit more...
You're a Virginia lawyer. You know that it is the bane of the existence of the defense bar and the glory of the plaintiff's bar to have non-suit. Virginia is one of the only state like that. You can't get costs assessed against you. I've had it done against me. They looked at the jury and didn't like what the jury looked like. They said, non-suit.
You're right.
It's
a very powerful weapon for the plaintiff.
6 months or the end of the statute, whichever is the greater.
This way, Your Honor, we reserved our rights, and we decided that it was the best strategical maneuver because we wanted to have an opportunity to look at the defendant's argument a little bit more, and we still have the non-suit. We haven't really lost anything. So,
You could have done all that without moving to vacate the non-suit.
except as I'm explaining, the court would have lost jurisdiction within 21 days. We wanted to vacate the non-suit so that we could have a little time to do some more research. Upon further reflection, it was unnecessary. We could have non-suited and refiled. But
That would have been a more precise way and a cleaner procedural way.
it would have, and I submit that that's exactly why the defendant removed us, because they didn't want us to be able to do that. I mean, we were very cautious, and we did what we thought was right under the circumstances, still having the right to take a non-suit.
The strength of your argument, you contend, is that on the day the suit was removed to federal court, the suit had not been dismissed in state court. Is that correct?
No question it had not been
Forget about
dismissed.
jurisdiction. The case had not been dismissed.
It was alive and kicking. We had a motion to amend the complaint on for the next day.
And there are a litany of things that the state court could have done and ruled later, but we don't know what they would have done or could have done because it's removed.
Correct.
All right. So, and your point is that you still had those arrows in your quiver, and that is non-suit, persuading, all those kind of things, but you didn't do that.
Absolutely. And that it was
But
error.
Assuming the removal was proper, and I've seen no indication that from you that the removal was improper, the district court has to decide what the state court would have done. And I think here, since the procedural question, that I think Judge Davis is right on the point. I don't think state law becomes irrelevant at this point because the whole procedural question was born and growing to maturity within the state court system.
I think
I'm not sure that federal rules of service of process just take over. I think that the procedural history of the case in state court can't be ignored.
I think the federal rules do take over, but
Oh, they do for many purposes. They would for summary judgment. They would for a good many purposes. But here, the, the whole case was litigated extensively under state procedure and state law. And, you know, that's different from the way the federal rules of evidence kick in, and it's different from the way a summary judgment motion is decided and everything. The case, for whatever reason, was litigated under state rules of procedure. And I don't think we are just free to ignore that, because that's what you were governed by at the time.
We would absolutely have been governed by state procedures had we stayed in state court. I think to answer what I'm hearing as your question, Judge Wilkinson, is was it Judge Lee's job to sit in the shoes of a state court and decide what a state court would have done? And our answer is no, not to the extent there was any discretion afforded a state judge. All the defense case...
I'm so glad to hear you say that. Could you elaborate? Because that's exactly my question. I think you agreed earlier that a state judge would have had a broad discretion whether to dismiss your case or not.
Yes.
With or without prejudice, to the extent that Virginia recognizes any such thing. And yet you just said to Judge Wilkinson, if I'm following you, that Judge Lee, though he sits as a state judge on this motion to dismiss, doesn't have the discretion that the state judge would have had. And I find that very difficult to comprehend.
I think if...
Have I correctly given an account of your position here?
I think in interpreting and looking at the applicability of state procedural rules, Judge Lee had the job of deciding whether it was mandatory, whether there was no circumstance by which Ms. Rice could have continued in the state court. So
okay,
to that extent...
I'm with you.
To
so
that
if Judge Lee erroneously thought he had no discretion but to dismiss the case, then you're here on legal error, and we apply a de novo standard of review.
Right.
And he did.
But if he understood, or if we're persuaded that he understood, that he had the discretion whether to dismiss the case or keep the case in federal court, then do you agree that our standard of review is abuse of discretion?
No.
And why not? So Judge Lee has less discretion to dismiss the case than a state judge would have had under exactly the same circumstances. How can that be?
Because well, first of all, Judge Lee found that dismissal was mandatory.
Okay, so we'll put that to one side for a moment. How can Judge Lee have less discretion than a state judge?
Because he's applying state procedural rules in a federal case, and it's just a matter, I think it's a matter of federalism.
You mean because it's a Title VII case?
Well, because
as opposed to a motor tort?
Because he's in federal court. And I think Judge Lee, in some parts of his opinion, he said he has to find out whether the state court had to dismiss the case, and he found that in his opinion. So I think even he understood that he...
discretion to the extent that if there's due diligence in trying to serve process on the defendant, then there's discretion on the part of the state court judge to find the due diligence. But, as I understand it, you haven't raised a due diligence claim here. You haven't said something like, well, we really tried to find these defendants. We couldn't exactly serve them, or we had problems finding out the address of this or that person. That we made an attempt, but it didn't work out. There was no claim along that. You've got to ask, what would the discretion hinge on? And normally when you have these with respect to time bars, we have this in filing notices of appeal and everything. We have an excusable neglect standard, and the due diligence formulation is sort of a parallel to an excusable neglect standard. But there wasn't, and that's what discretion is when you fail to meet a time deadline. Is there some reason? But the only reason that you've given us was that the defense counsel said something, and you sort of took their word for it. And that wouldn't have afforded a state judge or the district court in this case that kind of discretion. You haven't made the case that the district court should exercise discretion in your favor. That's the problem.
Your Honor, I see that my time is up. May I? Oh.
Would you mind?
Certainly, or I'd be happy to answer it now, whatever.
Well, go ahead and answer it now, then. But
I think
you have rebuttal time.
I think the Collins versus Shepard case, the Rutter versus Living Centers of Virginia, and the Fry case all stand for the proposition that the state court in Virginia has discretion to consider factors other than just due diligence, that there has to be a hearing to consider all of the facts and circumstances. And I submit that it is within the equitable power of the state court in Virginia to consider all of what happened here, including the 17 days where this plaintiff, by definition, could not have obtained a summons and would have been impossible to serve the defendant, so that the state court could balance the policies and objectives of the one-year service rule with the non-suit statute and the computation of time statute to say, well, under the facts here, it would be unfair and inappropriate and an absurd conclusion, like the Fry case found, to allow the plaintiff to perfect service, as we did, as the defense admits, but that it's going to be dismissed because it's untimely. So on the facts of this particular case, the state court would have had the discretion.
I understand your point.
Thank you, Judge.
You've got some rebuttal time coming to you as well. Thank you. All right, let's hear from the other side in this case. Mr. Meister.
Thank you, Your Honor. Douglas Meister on behalf of appellee, co-appellee, Alpha Security. And if you're curious, I'm not the counsel that was involved in that discussion about the, that was Mr. Robinson with Ms. Kelly. I have one, maybe two issues I'd like to focus on in my time.
Can I ask you one really quick question? I really wanted to ask Ms. Kelly. No, I'm talking to counsel, I'm sorry. If one of her points is that they couldn't obtain a summons during the period of the non-suit, correct?
Correct.
My question, and she can answer later, if she'd obtained the summons, say a week before the non-suit, would that argument remain the same? Does the summons abate or die with the filing of a non-suit? Or could you serve a defendant during a period of non-suit if you already have
I see no reason why not. Absolutely not.
Okay, thank you. I didn't want to take up any more of your time.
Okay. My issue here is this matter is moot. Given the process of how we've got here, the argument falls back on, does the appellant have or should have been afforded on 120 days under 1448 to make proper service, timely service, as in an original case in the district court. That really doesn't matter anymore because the appellant didn't. That was never preserved for argument here because the appellant never did try to serve. Well, I don't know if they tried and didn't find us, but certainly original service has not been made during that 120-day period. There's no way to fix that unless there's no...
It hasn't been made under the federal rules.
There's certainly no federal statute that allows her an additional time outside of 120 days.
So the question is, does federal or state procedure apply?
Well, state procedure has already said that it's got to be filed within a year. It's outside of a year. There's no dispute that it's outside of a calendar year. I mean, there's absolutely none. Now, the appellant argues that it should be told for various reasons, which I'll leave to our briefing unless you have questions.
But the point is that regardless of whether we decide federal or state procedure applies, it's outside the time limit.
Absolutely. And that's through no fault of the plaintiffs. The appellant has twice exceeded the filing period and not filed timely.
You mean no fault of the defendant?
I'm sorry, no fault of defendants, appellees here. There's no way to fix this. This is procedurally dead.
The thing is, it could so easily have been avoided.
Unfortunately, well, depending on the side we're on, it wasn't.
I mean, a year is a very long time for service of process. Have most state rules have a year?
No, not at all. It is a very long
It's
time.
It's a very generous time limit. I mean, it's not asking the impossible of a plaintiff to serve process within 1 year. I mean, that's one of the most, I think it's one of the most generous time limits in any of the states, isn't it?
Yes.
And there's just, when you talk about excusing it and everything, you have to take into account that you had 1 year to do it. It's as what is it, 3 times as long or 4 times as long as the federal rules allow?
120 days is 3 months. That's 4 times as long.
And it's not a hard thing to do.
Not only was it not hard, once the plaintiff below decided to serve us, they did it in 1 day. They came to us in 1 day, and our resident agents were not available. The next day, when our resident agents were available, they made service.
But the district court didn't dismiss the case on the basis of the 120-day federal statute.
No, because, in fact, as a coincidence, as of the day the district court actually heard second set of arguments, January 11th, that was still timely for service.
Right. So now, let's take that aside. Point well taken in terms of the argument on 120 days. Let's put that aside for a second. The reason that the district court gave was that the case was already, I call it a dead letter, but a dead case when it got here. That seems to suggest that the court is clearly saying that I'm not looking at whether or not I should look at diligence or whatever. I can't. It's dead. Isn't that wrong, though?
I don't believe that's quite what was. The court did say it was jurisprudentially dead.
Okay, well, we don't know what jurisprudential means, but we know what dead means. So let's deal with dead.
And I believe
He said it was dead. So, but that's not correct, though, is it?
it's anticipatory. It's dead in the sense that a Virginia judge who would be given this set of facts would rule that it is outside a calendar year and can't be revived.
So Judge Lee killed it.
He then went on to consideration of due diligence as to whether or not there was due diligence in an exercise of discretion that might have saved the case under Virginia law. And he found there was not.
What if it was a fait accompli for the state court? Why would the court grant the vacatur of the non-suit?
We had not been served. We don't know. We have no idea what arguments were
But that would
presented.
suggest that the court thought that it was something to continue on. Otherwise, you wouldn't grant it. Because the court knew then that they were at the 1 day left point there. And so if 364 waiting that long, you can't prove diligence. You're not going to be able to prove 1 day more. So that would suggest that the state court would have done differently because it gave her a new breath of freedom, if you would.
I don't see how it gave her any freedom except for that one last day.
So you would submit, well, then that's what to the one last day. Well, then if it's told for 17 days, didn't they do that one last day? Because the 31st would have been that 1 day, wouldn't it? Because it wasn't the last day; it was the anti-ultimate day, right? So then once the toll is there, then
We don't believe it was told. We don't believe it told anything.
well, how could the statute? So you don't think it did?
No, absolutely not. There's nothing in Virginia law that says filing a non-suit tolls the time in which a non-suit, and then vacating it, tolls the time in which a non-suit may be served.
And you could have gotten an answer to that question from a Virginia judge if you hadn't removed the case.
There's no difference in Judge Lee applying Virginia law.
Sure there is.
than a Virginia state
Sure
judge.
there is. Judge Lee is Judge Lee, and a Virginia judge is a Virginia judge. There's every difference in the world. I'm not suggesting the outcome should be the same, but my point, I think you know my point, it's simply that from a strategic, tactical perspective, I don't know what's going on here. I was surprised to hear that there had been conversations between counsel. I don't know if that's in the record, but I was surprised to hear that this morning. But in any event, a defendant who chooses to remove a case to federal court has made an option to get a decision from a federal judge reviewed by this court as opposed to a decision by a Virginia judge reviewed by the Virginia Court of Appeals and perhaps the Virginia Supreme Court.
I don't think this issue is complicated and requires extensive knowledge of Virginia law
Coming
versus
from a
federal.
former civil procedure professor, this is very complicated.
Thank you, sir.
Thank you very much.
It's all this time.
Anything else?
Yes, go ahead. You've got, let
No,
the lawyer come up.
No, go ahead, since you're on the time. Go ahead. Let the other lawyer come up.
Thank you.
May it please the court. I'm Steve Robinson, and together with my associate Nick Sanfilippo, we represent Budget Motels and Waterloo Hospitality, which for purposes of argument we'll refer to as Budget Motels. I think what's important, first of all, to go back to address some of the concerns the court has, is to look at the calendar. The calendar's in the brief, but I would like to just give the court 3 or 4 dates to consider. First of all, this case was filed on August 15th, 2011, the 89th day under the 90 days from a right to sue letter issued by the EEOC. On August 3rd, well within the 1-year period of time in which service could be affected, the plaintiff files an unopposed motion in Fairfax for a non-suit. Unopposed because the defendants hadn't been served.
Unopposed because it wouldn't have made any difference.
Correct, yes.
It's about right.
By right, and as Your Honor notes, I've sat there and watched the motion to strike evaporate as the plaintiff gets up and says, we're taking a non-suit, thank you very much.
Right.
So rather than do what, frankly, I think would be logical to get back to Judge Davis's point, if you're filing a motion for a non-suit on August 3rd, why aren't you getting a summons and going and serving? I don't know the answer to that. But frankly, had that happened, we wouldn't have been here today. But what happens instead is Judge Roush enters the order on August 14th, a non-suit order, unopposed. The plaintiff then realizes, and again, in all candor with the court, it was a conversation with me, because I called the plaintiff's counsel. This is not in the record, but I'm happy to share it because I think there's some interest in it.
How'd you find out about the case?
Your Honor, we monitor the cases in
course you
Fairfax
do.
regularly.
Of course you do.
Sure.
Of course you do.
I mean, you know, Fairfax in those days was in the beginnings of their electronic docketing system, and frankly, we had a paralegal who went by, you know, probably once a month.
So you get a lot of business.
Well, we knew the case.
Well, maybe not a lot of.
Your Honor, we knew the case was coming because we'd represented the defendants in the
Sure.
administrative situation. And frankly, we were counting the days on the right to sue. And frankly, we only followed the docket in the federal court. It never occurred to us until several months after the case was filed in the Circuit Court of Fairfax that indeed was where this court was going to have jurisdiction.
You still had a right to service of process.
Absolutely.
No matter what you knew or didn't know.
Exactly. That's exactly right. So when the plaintiff goes ahead on the 16th or 17th day, on August 30th, and again, unopposed, as Judge Gregory probably knows, calendar control in Fairfax, 8:30 in the morning, you walk in, Your Honor, I want an order. The judge signs the order. The judge doesn't have the file in front of himself or herself. Under the plaintiff's theory, the case is now active on August 30th. That is the last day to serve.
If there's no tolling.
Even if there is tolling, it's the last day to serve. Because,
I don't understand that.
well, Your Honor, the original lawsuit was filed on August 15th, 2011.
Okay.
Non-suit order entered August 14th, 2012.
Okay, I see.
1 day left. So on August
Even if
30th,
there's tolling, the 14 or 17 days or whatever.
doesn't make any difference.
Doesn't make any
I
difference.
mean, again, and we've argued it in our brief, and I think the district judge correctly found. And again, as you all know, Judge Lee had the benefit of sitting on the bench in Fairfax for about 10 years. So
What date was it? Again, just finish Judge Davis answering, but it's quickly. What's the date that the vacature was entered?
it was August 30th, Your Honor.
Okay, that's what I thought.
And if you look in the joint appendix, and I can give you the site if the court wants it. You look and you see there's a handwritten notation to the court in Fairfax at 9:38 a.m. on that day to issue summonses. So on the last day that service could be made, the plaintiff got her summonses.
Yeah, but wouldn't it be the last day to serve would be August 31st?
Your Honor, with all due respect, it wouldn't be,
Why not?
because she had 1 day left when the non-suit was entered.
That's right.
Okay? On August 30th, the case is now back on the docket. To use the plaintiff's phrase, it has to be live and kicking because otherwise they couldn't have gotten a summons.
But it's back on the docket, but the date now is as if it was August 14th.
I think, Your Honor, it would be August 15th
Why?
because the case was non-suited on the 14th. It was an active case through the 14th. I mean, theoretically, to get back to Judge Davis's...
Yeah, see, that would be the same thing if that was her last day. If it was her last day, she got the non-suit, then the day it is vacated would be the same day now she has to serve. But when you have one more day, then you have to have one more day after it's vacated, which would be the 31st. How would that not be?
Your Honor, I think the reason it wouldn't be is because the case was in existence on August 14th because it was not dismissed until that day. So it was, again, to go back to the appellant's phrase, it was alive and kicking on the 14th. So they had 1 day left.
I agree, right. The day that, right, exactly. They have 1 day left.
All right, and August 30th, again, because the non-suit order has been vacated.
Put back on the docket.
Correct.
She had one more day.
So that's the equivalent of August 15th because the case was alive on the 14th, Your Honor.
Oh, I see. Okay.
I don't, okay. I see.
Seems
All right.
like Judge Gregory's got the better of the argument. If the non-suit is entered on the 14th and vacated on the 30th, then the 30th becomes the virtual 14th.
Yeah, it would have
And so the 31st becomes the virtual 15th, right?
to be.
Well, and frankly, we need not.
Pretty metaphysical here.
Well, it is very much, Your Honor. And with all due respect, obviously, I think the case can't be alive. But the 364th day can't be both the 14th and the 30th, which I think, with all due respect, would be the circumstance under the argument that Your Honors are positing. Because the case did exist on the 14th. That's day 364. Everybody agrees with that. The case ended on day 364 because the non-suit was taken. So then we have the case is back.
This might help me real quick.
Yes, sir.
If the 14th of August was the last day, right? Okay? And if in fact it was vacated as it was on the 30th, what would be the last day to file then?
I don't think there would be a last day.
Well, see, in other words, you said
That's the problem.
you couldn't even do it that day.
That's correct. Well, that's correct, Your Honor.
I don't see how that could be.
All right. Well, nevertheless, again, I don't think that's an issue the court needs to reach because, as the district court correctly found, there clearly was, in essence, no effect for the non-suit because, as we cited in our papers, and nobody really seems to debate that. In fact, the appellant in her argument also agrees, if you look at her argument before the district court.
If you vacate the non-suit order, it deprives the non-suit order of any effect, doesn't it?
That's correct, Your Honor. And if
So it would leave would that leave the time period continuous?
yes, sir, Your Honor. And if you look,
We don't need to get into this, whether there's 1 day or not, because if you vacate the order to the non-suit, it's as if the non-suit never happened.
that's correct, Your Honor. If you look at page 85 of the joint appendix in the colloquy with the district court, Judge Lee asked, quote, "Tell me what your view is of the word vacate. What does vacate mean to you?" Ms. Kelly, "Well, that other order doesn't have any effect, and we are just back like we were before."
And didn't she mean continuing effect?
I don't know what she meant, Your Honor. I always tell witnesses in depositions they can't tell me what other people thought, and I'm not about to do that here.
Well, what's the case law that supports Judge Lee's interpretation
Of vacation or...
to vacate wipes out the whole period of non-suit?
Your Honor, we have cited a series of cases in our.
But there's no specific holding by a Virginia
That's
Court of
correct.
Appeal.
There absolutely is not. There is
And you
generally.
could have gotten such a holding if you wanted to stay in Virginia.
Well, let me address that question, Your Honor, because maybe that's a little bit of the elephant in the room. This was a Title VII case. A Title VII case that when suit was filed, the operative events were now 5 years old. Obviously, a lengthy period of time. Witnesses move, they die, they forget things. Serious restrictions on taking out-of-state depositions and discovery in the Virginia State Court. Again, as you all know, there's no Rule 56 or anything close to that in a Virginia State Court. In fact, it's just the opposite. Depositions cannot be used in a summary judgment motion.
Plaintiff's deposition.
Any deposition.
Really?
Any depositions. So the situation that we had was, number one, it's a Title VII case. It's been around for a long time. Number two, with all due respect to the bench in Fairfax, they don't see many Title VII cases. We wanted a judge who was familiar with the case law. Number three, we would have been severely procedurally hampered by the lack of ability to take broader discovery. And frankly, fourth, summary judgment probably never would have been a possibility. And again, as your honors know from sitting on this court, a lot of employment cases go on summary judgment.
Well, I think there's a real question here as to whether state or federal procedure even applies. Because that in itself is a bit of a difficult question. And so I'm not sure we need to resolve it if it's untimely under either law. The question I look at is, and this bears on the equitable tolling here, the plaintiff here had a long amount of time to perform almost a ministerial function, but a perfectly straightforward function, which is simply to serve process. It's not an arcane thing. It's a part of every single lawsuit. It wasn't done until after a year after filing in Virginia. It wasn't done within 120 days in federal court. And there's no attempt here to establish one of these procedural tripwires or to have plaintiff's case thrown out of court as a result of being blindsided by some kind of rule. It ought to be a matter of second nature to simply serve process, give the opposing party notice of a summons and complaint. And people do that simply as a matter of course when something is filed. And when you look at the extraordinary delay that took place here, the question is, should we bend over backwards or try to work things around to salvage something that I don't think was litigated in the way that it really should have been. And it almost encourages an absence of some kind of precision or due diligence in courts below when we do it. This all of it could have been avoided. Difficulty is that plaintiff has created problems for herself, unfortunately, but that's what's happened. When you look at it as a whole.
That's certainly been the defendant's position all along. As the court's well aware that Virginia, both statutes and rules make it clear that no judgment can be entered in a case in which the complaint has not been served in a year, absent an order from the court finding that due diligence occurred. There's not even an attempt to argue that due diligence occurred here. And my time's running out. I'll be happy to answer any questions.
But you would agree that if you file within 1 year, being 364th day, due diligence has nothing to do with it. 364
would be okay because you'd be within a year.
Right, that's what I'm saying. So, but so due diligence really almost is a red herring in a sense in terms of that's not, the point is, the argument is that it was filed timely. Because their argument is that there was a tolling and that was timely.
Their argument is premised on the 17 or 16 days, depending on however you count,
Exactly.
not having any impact, which would mean the order vacating the non-suit was a nullity, which, again, I'm out of time and I don't want to press my luck with the court, but I think we've cited the decisions in our brief, and I'll rest on our brief on that issue. And I'll be happy to answer any other questions that the court may have.
The point is that the vacater of the non-suit was entered.
Correct. Yes, sir.
Okay.
Thank you, Your Honors.
Ms. Keller?
Your Honor, I'd like to just address a couple of the points that seem to be of concern. Judge Wilkinson, I understand that you are concerned about the long period of time that a plaintiff has served in Virginia.
Counsel, your time would be better spent. You don't have much time to deal with. Why don't you deal with it? What about the 120 days?
The 120 days?
Why didn't you file? Why didn't you serve it?
What do you mean?
After you're in federal court, why didn't you serve it?
Well, because Judge Lee denied their motion. Let's don't forget about that. Judge Lee denied their motion, and therefore we expected we were going to be able to proceed, but he took until December to change his mind. So we wouldn't serve if their motion had been denied and there was no need. 1448 says if service has been found defective, we have the right to reserve. And I think the real issue is getting lost here. The only thing that
So the
Judge...
court had already ruled in your favor?
In our favor, correct.
Okay, so,
Judge Lee initially denied their motions.
so you have a reason for not filing in 120 days.
Yes, sir.
So this is additional estoppel, if you would. The judges are stopped from claiming you have to do something that the court made you think that he was ruling for your favor, correct?
Defense, right, and defense never raised that below, but as a matter of fact, Judge Lee had denied their motions.
Right.
But I think the real fundamental issue is, was the case alive when it arrived? And you don't have to accept any tolling argument to find that it was. Fairfax record says it was, and the very fact that we could have taken a non-suit. If the non-suit order was vacated, then by definition, we still had a non-suit as a matter of right. And there is no question that under controlling Virginia Supreme Court law, we could take a non-suit even after the expiration of the 1 year, even after the 1 year for service expires. As generous as that is,
And that's the holiday situation you're relying on for that.
No, I'm not. I'm relying on Waterman versus Halverson and Berry versus FNS Financial Marketing. Virginia Supreme Court cases where the court rejected defendants' argument that they had a right to a dismissal, that there was no jurisdiction. And
is there any limit on the number of non-suits?
under the Virginia Code, plaintiff has one non-suit as a matter of right,
Yes.
which we still had by virtue of the vacation of that order, and we may have additional ones in the discretion of the court.
Right. So by vacation, by being vacated, you still had your one by right.
Right. That's really all that we have to show to prove under Virginia law this case was alive.
Right. You're
There
What's
are
left Virginia?
under Virginia law, under controlling unquestionable Virginia law, we could get lost into who could have and would have done what. And that's what I meant by it was inappropriate for Judge Lee to step in those shoes. Really, Judge Lee just has to say, is this case alive?
I see.
It is alive. And,
Because Judge Lee can't grant a non-suit,
well, he can't.
but he can give you all kinds of time to fix things.
It was the defendant's choice to remove, and they really should not be heard to complain about the plaintiff's right if service was found defective.
You're arguing this as though it's the defendant's fault and that, that the defendants were aware of this, so we don't need to worry about service of process or it's defendant's fault to remove. They have a perfect right to these things. They have a perfect right to service of process. They have a perfect right to remove. The removal statutes give them that right. And then a federal judge may decide under state law all the time. Although it's not clear to me that state procedures still govern. Because, I mean, it's basic Hornbook law that federal procedure governs the removed cases in state court. Just because it's removed, it doesn't mean necessarily that federal that state procedure continues to prevail. I'm not at all sure that the federal rules don't control here. The thing is in federal court, and even if you did it only as a protective matter, you would think that you would serve within you would serve process within 120 days. I'm just not convinced that any of these problems needed to arise. It has been made vastly more complicated by the fact that someone didn't even take the rudimentary step in either state or federal court of clearly serving process within 1 year, which isn't hard to do, not at all.
I understand Your Honor's comments, but, the Virginia legislature made that balance in allowing the plaintiff the right to 1 year and the right to a non-suit.
Why didn't you serve process? Why did you move to vacate the non-suit? I don't understand any of it. I don't understand why you didn't serve process in a way that would be timely. I don't understand why you moved to vacate the non-suit.
Well, I've explained why we moved to vacate the non-suit, and it was probably unnecessary, but we still have our non-suit as a matter of right, which means the case was alive. As the Virginia legislature must have anticipated, sometimes things happen in the course of a year. 90 days is a quick statute of limitations. We met that. Everybody concedes that. I was local counsel, and there are a number of events that just took place, and I was doing an amended motion for judgment. I'm allowed to rely, just as the defense, Judge Wilkinson, completely respect and agree. I understand, I believe your point, the defense has a right to remove. Well, we have a right to wait an entire year if we want to. We have a right to take a non-suit if we want to. We still had that right to take a non-suit.
But that then raises the question as to whether the effect of the vacatur, and the effect of a vacatur is to make the non-suit order a nullity.
Which means we could have taken it again.
And to throw the filing date of August 31st past the 1 year period. I don't think it's a matter of 14 or 15 days. I mean, we can't change the whole notion of what a vacatur represents and what the effect of it is.
But you don't even need to reach that. The fact that the plaintiff had a right to keep her suit alive in Virginia means it arrived alive in Judge Lee's courthouse.
And your point is that Collins v. Shepard and Berry are the two cases on which you rely?
Well, Collins and Rutter show that the state court has discretion, and Fry, that it's not just due diligence, that there's the balancing of Virginia statutes.
Yeah, but my point is, you could have obtained, even had you not served process
Yes.
on August 31st,
Yes.
and assuming the case was not removed on September 13th or whenever it was, you could have sought and obtained a non-suit in September, October, or November of 2012.
Absolutely. Unless the
Virginia
court
law.
had already dismissed it, obviously. But yes, the Berry case, the Waterman case.
And the reason for that, in whole or in part, is exactly because you got a vacator of the original non-suit. Is
Correct.
that right?
Correct. So we had it as a matter of right. We still had a
Because
non-suit.
the first one didn't count.
Because the first one didn't count. It was vacated. It didn't exist anymore. We could also, even if it did count, have possibly gotten a second one as a matter of discretion. But we still had one as a matter of right, and we still could have taken it even after the expiration of the one-year service rule, Berry and Waterman
You
cases.
want all the benefits of that, and you don't want to accept any of the drawbacks of it.
Well, we'd like the benefit of either the state, as it stands here, if the defense wins, we are denied all our basic, powerful procedural options as a matter of right that we had in state court, and now we're left with none in federal court because they chose to remove us quickly without asking for the state court to interpret its own procedural rules. That's not fair. And the Brazil case, the only case that I've been able to locate from this court,
They don't have to do
noted.
that prior to removal.
I'm sorry?
There's no law of removal that says defendants have to ask for this state court ruling or that state court ruling before they remove. You don't have to do that. You can remove the case. It happens sometimes within a day. You don't have to sit there and ask the state judge for a ruling.
You
on
don't,
state
but they
procedure.
chose-
They might not even think it applies. I don't know where that obligation comes from.
They chose to remove it when they did, and they removed a live case. Plaintiff could have kept it alive, and that's really the only question before this court. Judge Lee was wrong
And
in dismissing
remind
it.
us
I
why
do have
Judge
my red
Lee-
light, Judge. May I?
Sure. Judge Wilkinson's been enormously generous today, as you all saw, and that's a good thing. Why did Judge Lee get it so wrong? If it's so obvious, just let me finish. If it's so obvious, as you say it is, and now it appears that you're right, that you could have taken a non-suit had the case remained in state court, regardless of whether and when you served process. How did Judge Lee get that so wrong?
I can't speak for Judge Lee.
But what did he say about it?
His opinion is conflicting, literally, in different parts of it. In one part of his opinion, he says the vacation of the non-suit order brings it back exactly to the status quo ante. And then later, he seems to have some doubt as to whether the plaintiff could take the non-suit. How that doubt came about, what he's talking about, he cited no statute, he cited no law, and I don't know why he had any doubt.
Okay.
That was part of the reason we appealed it. We think it really is plain wrong. Are there any other questions that I could answer? I'm
Thank
sorry.
you. We'll adjourn court and come down and recounsel.
This honorable court stands adjourned until tomorrow morning at 9:30. God save the United States and this honorable court.